Hi, my name is Don Klawiter. I'm here today to interview John Shenefield, who was the Assistant Attorney General for the Antitrust Division and later Associate Attorney General of the United States during the Carter administration. John, you started your practice at Huntington Williams. Could you tell us about your early years of practice at Huntington Williams?
I'm delighted to, Don. I came down from the north to this sleepy little town, Richmond, Virginia, to be part of Huntington Williams, which is a great law firm. Had the enormous good fortune to work with two giants of the legal business in those years, George Gibson and Lewis Powell. Initially, I did almost everything: fence post cases, dog bite cases, corporate resolutions, just about everything.
How did you become an antitrust lawyer in the middle of that area of practice?
Well, as I look back on it, it's an interesting story. I was thinking about taking a job in Washington, and Lewis Powell walked to my office one day and said, "We want you to be head of the antitrust section of Huntington Williams." I said, "Mr. Powell, you don't have an antitrust section." He said, "Well, if you are the head of it, then we'll have one person in it, and your task will be to build the practice and build the section." And that was 1967.
You mentioned George Gibson and Lewis Powell. Tell us a little bit about your work with George Gibson, who was, again, one of the giants of the profession.
George Gibson was the most articulate speaker of the English language I think I've ever known. He taught me the value of each word. He taught me the value of nuance. He taught me the value of preparation. For him, I did general antitrust work, and particularly in the public utilities sector.
And what about Lewis Powell? Obviously, at a certain point in time, he left Huntington Williams to go on to higher callings, but
yeah.
I know you worked for many years with Justice Powell.
He was really my first boss, and the chief lesson I took away from that experience was the value of public service, of doing something other than for profit that every lawyer really assumes. When Lewis was nominated to the Supreme Court by President Nixon in 1971, the first person to visit him was Judge Hainsworth, who said, "Take your own people with you to get yourself confirmed. Don't rely on the Justice Department." And I was lucky enough to be one of those people he took. So up until 71, he was my real boss.
Let's fast forward to 1977. The administration has changed. President Carter is elected. How is it that you got yourself to go to Washington?
Well, I have to confess, I'd always had an interest in public service, in part from Lewis's lesson. I rather suspect, and there's some evidence to support it, that the critical event was some communication that he had with Griffin Bell, who was the Attorney General designate. After all, Lewis was the circuit justice for the Fifth Circuit, and of course Judge Bell had been a Fifth Circuit judge. And my guess is, and there was an article in the Post that tended to confirm this, that Justice Powell wrote a letter that said something about, "There's a young man in Richmond who really would like to do public service, and I can vouch for him, and he's terrific, and why don't you take a look at him?"
And Judge Bell did?
Judge Bell did. He must have thought it was agreeable enough to try it out, and in April of 77, I came up to Washington to be the Deputy Assistant Attorney General of the Antitrust Division of the United States Department of Justice.
And how long were you deputy?
1 month. And I've never quite figured out whether it was a tryout period or exactly what was happening, but in due course, my predecessor resigned and went into private practice, and Judge Bell put me in charge of the Antitrust Division May of 77.
And you were then you had to be confirmed by the Senate. You went through that process as well?
Went through that process. It was by and large trouble-free. Senator Kennedy was the chairman of the Judiciary Committee. Senator Javits was the ranking minority member. There wasn't any real opposition to speak of, and by, I can't remember, September, October, I was a confirmed head of the division.
Well, in your early days in the division, you were surrounded by a group of very interesting practitioners and really some of the legends from those of us who have served in the Antitrust Division of the Antitrust Bar. Who among that group of senior staff was most memorable to you and really most helpful to you when you were Assistant Attorney General?
Well, you're exactly right. It was an extraordinary group of people I inherited, and what's interesting to reflect on today is that not one of them changed when the administration changed. There was a political deputy, he left, but everybody else was in place. I recognized the extraordinary abilities of these people. It was sort of like the 1927 New York Yankees, one after another, a murderer's row of antitrust lawyers. And they all were excellent. I think if I had to pick one, as your question forces me to do, I would pick Hugh Morrison. He was the senior career deputy, the senior litigation deputy. In a sense, he was the conscience of the division. I was a 38-year-old kid, in effect, from Richmond, Virginia, and I needed his help. And I'll never forget a conversation I had with him. I went into him and I sat down and said, Hugh, I can't do this without you. I need your help. And he didn't salute, but he said, John, you're head of the division. I'm loyal to the division. We can do this together.
Very nice. I always thought of people like Hugh as the pillars that kept the building up.
Hugh was remarkable, and unfortunately he died early, but he was a wonderful, wonderful human being, and he had a pretty solid ability to hit a softball too. We had a front office softball team which we tried to play fairly regularly. He played just like everybody else. I had this mammoth office, and he would stand at one end near the fireplace, and I would stand at the other end, and we'd throw a football back and forth occasionally while just talking. He was a wonderful human being.
Terrific. At the other side of your tenure and the work you had to do, you obviously had to report to Judge Bell as Attorney General. Did Judge Bell have a style or an approach to being Attorney General that you could share with us?
Well, there are two things about Judge Bell that were significant. One is he let you alone to do your job. In effect, he said, you're in charge of the Antitrust Division. Don't embarrass me. Don't surprise me. But I don't need to know everything you're doing. The second thing, and remember, this was not long after Watergate and the horrors that visited on government and the American people. In effect, he said that the Department of Justice is going to be a politics-free zone. Called it the neutral zone. And one aspect of that was he simply did not want any head of any of the litigating divisions speaking either to the White House or to the Congress about matters in litigation. So my instructions were, if I got a call from some special assistant to the president, or if I got a call from a senator about a case, as opposed to a policy, about a case, I had to refer that to the fifth floor. And he enforced it, and it was, I think, a notable achievement that it was a success and, in effect, cleansed the system a little bit of all of the residue of Watergate.
Very good. John, I wanted to talk about a number of the developments and accomplishments of your time in office at the Antitrust Division. The first one that comes to mind, and obviously from kind of current practice and what's going on, is the Leniency program, and the fact that the Antitrust Division's Leniency program first came into effect when you were the Assistant Attorney General. Could you tell us how the thought process of how the Leniency program came about for the division?
Well, I wish we could claim that it sprang, sort of full blown from the brow of somebody in the Antitrust Division. It didn't happen that way. And it's a good lesson to what can happen when you have sophisticated defense counsel on one hand and creative and flexible people in the division on the other. Miles Kirkpatrick, who'd been chairman of the Federal Trade Commission, had stumbled across a price-fixing conspiracy in which one of his clients was involved. And he knew the ordinary probabilities, maybe it would never get discovered, but if it got discovered, things would be terrible. And remember, in '74, Congress had passed a statute that made price fixing a felony, so the stakes had gone up considerably. And he initiated a conversation in which, in a kind of a hypothetical mode, he said, John, suppose I can bring you evidence of an indictable price fixing conspiracy. Why should I do that? What's in it for me? What's in it for my client? And we had this conversation back and forth. I brought in my senior staff. Everybody could see the great benefits of it. there was a little nervousness about the politics of it. How would we explain to the public at large, to our oversight committees, that we were in effect giving a pass to a, quote, felon? But after a lot of reflection and thought and back and forth, we decided the upside was just too great. It played on the instability of a cartel in a perfect way. The economists loved it. And so we made a deal with Miles's client, and they got leniency. That was the first one.
Did you have trouble with the prosecuting staff? I mean, you had some pretty hard-boiled prosecutors in there who would, I think, see the idea of giving a felon a pass as being totally contrary to what the reason they got up in the morning.
There was some of that. I mean, there's the prosecutors who have vengeance uppermost in their minds, and those folks didn't like this at all. But by and large, calmer judgment and people who were focused on the mission of the division, which was to cleanse the economy of cartels, in a sober second thought, came to the conclusion, look, this is just too good to pass up. If we can make it more likely that we will find out about cartels, that's all to the good of the economy, to the American consumer. Why not go with this? And vengeance has its place, but there'll be other co-conspirators there who don't get the leniency treatment. The problem with leniency at that time was that we didn't go the final step and make it absolutely unconditional, and that was a sort of a political judgment. We had to kind of get started with the policy. Then in 1993, they took the next step, and history is, as we all know what happened, it's become an enormous success.
An absolute success,
in that
yes.
15-year period.
Tell us a little bit about the announcement. I know you announced the matter to a group of corporate counsel, and I think it's an interesting story. Why don't you tell about
Well,
the
it was.
decision?
I think it was the corporate counsel section of the Chicago bar or something like that. I remember getting on an airplane, very pleased with this. I was going to make a luncheon speech, announce a great new initiative. I made the speech, announced the initiative, and quite to my amazement, the reaction was sort of tittering throughout the hall, a kind of a nervous laughter. Some of them obviously thought this was a big joke, and this was, was a joke that had no taste to it. Others thought this was a cynical effort to lure them in, and then we'd hammer them once they walked in the door. In fact, I think there was just general disbelief initially, and we had to keep emphasizing, no, this is a real initiative. If you bring us evidence of a conspiracy, there will be benefits for you.
Well, that was the beginning of many, many cases. So
it was indeed. We got it those years, 1, 2, maybe 3 a year, something along those lines, but the lack of predictability, the conditioned aspect of it, made it less effective than it has since become.
Another of your initiatives when you came into office was the shared monopoly program.
Right.
And that was something, again, new and different to the division in many respects. How did the idea of shared monopoly investigations and potentially prosecutions come to you and come to the division staff?
Well, it was a result of listening. For the first 5-6 months I was in the job, I asked everybody with whom I came in contact, what should the Antitrust Division be doing? How can it do what it's doing better? How can it improve its record? And 2 or 3 of the people whom I really respected, giants of the antitrust world, said that there is this problem somewhere between explicit price fixing on one hand and pure oligopoly, conscious parallelism pricing on the other. And we think there may be something you can do, and you ought to take a look at it. It came out of the works of George Stigler, but the people who talked to me about it were Dick Posner, who was then back at the University of Chicago, and Phil Arita, from whom I had taken antitrust at Harvard Law School. Both of them focused on this as something that wasn't really being addressed. It wasn't really explicit hardcore price fixing, which was criminalized, but it also wasn't just oligopoly pricing. So I tried to get the division to focus on this. We instituted an enormous number of investigations or inquiries. We distributed it across the staff. Some people had to be dragged kicking and screaming into this. They didn't want to have anything to do with it. Others took to it naturally. The economists rather liked it. George Hay, who was my director of my economic policy office, thought it was a very sensible idea. And the bottom line, we didn't find a case that was really a sensible case to bring. And ask yourself, what would the remedy have been? That was the other huge problem. But we turned over a lot of stones. We found some things that were even more serious than shared monopoly. But it was worth an exercise. It was an exercise well worthwhile. I'm glad we went through it.
It seemed like it was more an exercise of the division actually looking at industries and doing the industry analysis that many people often talk about the enforcement agencies doing, but they never get a chance to do, it seems, in the current environment.
I think that's fair. Remember, the division, much of it was focused and remains today focused on the criminal aspects. That comes at you as a fact situation. You either have an agreement or you don't. And it doesn't require you to do any of the industry analysis. And then at the other extreme, the big monopolization cases, I think this was a good way of acquainting the division with a lot of different industries and teaching them how industries worked, how competition actually worked in the real world. And I think, again, no cases. I thought it was worthwhile. In a sense, it proved that there wasn't an easy way to get at it, and there wasn't a way short of violating some sense of the Bill of Rights that we could deal with the kind of signaling practices that people were concerned about.
Okay. One of the other big initiatives during your tenure, and we've just been through the Antitrust Modernization Commission, but there was a national commission that you chaired in the 1970s when you were Assistant Attorney General.
Right.
Could you tell us how the National Commission came into being and sort of what the objectives were of the commission?
It was really something that Griffin Bell started. He pushed the stone down the hill. He was troubled by the fact that the division was having trouble with the IBM case. And by that time, 1977, the IBM case was 9 years old, if I recall correctly. And it still wasn't, we weren't through the trial, and it seemed endless. And he was worrying about whether there was a way to make trial of big cases like that more effective, more efficient. So that was part of it. But that was basically defensive. I mean, we were sort of in a position of trying to see how we could do our own job better. And we thought it made sense to add something to that in which we were on the offensive, and that was deregulation. So the twin objectives of the commission were to recommend ways in which to improve trial of very large antitrust cases on the one hand, and second, to push the deregulation ball forward. It started with Judge Bell. It was picked up enthusiastically by our senior staff. President Carter liked the deregulation aspects of it a lot. Congress liked it too, and so that's how we got started.
Well, unlike the recent AMC, you had a number of commissioners who were members of Congress.
Yes.
And it was a very, very different, it was much more of a political dimension. Whose idea was it to put senators and congressmen on the commission?
That was Judge Bell. Judge Bell thought, I think absolutely correctly, that if you have them buy in to the process in the first place, they're more likely to support the results at the end of the day. And so we had senior people from the judiciary committees of both houses. We had from the Senate Ted Kennedy of Massachusetts, Orrin Hatch, we had Jake Javits from New York, we had Bob Morgan, and there was and Howard Metzenbaum, of Song and Story. That was the Senate group, and then the House five were Congressman Rodino, Congressman Seiberling, Barbara Jordan of Texas, Bob McClory of Illinois, and Charles Wiggins of California. So we had 3 Democrats and 2 Republicans from each house. And I'll tell you, Don, one of the daunting things about being a 38-year-old and chairing this commission was sitting in we had all of our hearings were in the Judiciary Committee hearing rooms in the Congress, and sitting in the chair of the Judiciary Committee with Peter Rodino on one side and Ted Kennedy on the other, and running this 22-person commission was daunting and exciting.
Absolutely, absolutely. Well, what came out of the commission in terms of both the litigation side and the deregulation side?
Well, in terms of the trial of a case, I think the best you can say is we got enough recommendations together to put together a minor civil procedure sort of adjustment package. It was enacted into law in, I think, 1980. It wasn't a major issue. It wasn't a set of major recommendations. But it focused people's attention on the importance of trying cases and trying them efficiently. And it made a difference in the AT&T case, which we can come to in a moment. On the deregulation side, this was an initiative that the Ford administration had started. The Carter administration embraced enthusiastically, in particular by way of people like Fred Kahn at the CAB and me at the Antitrust Division in league with Senator Kennedy of the Judiciary Committee. And we ticked off one industry after another and suggested ways in which deregulation could move forward. Transportation, insurance, agriculture, one right after another.
And the division then, as a result of the work of the commission, got involved very decisively, I think, in legislative proposals to deregulate?
Absolutely. I think, if I've never done the actual count, but my intuition is that if I counted all the testimonies I gave before the Senate and the House, and there were dozens and dozens and dozens, an absolute majority would have been on the subject of deregulation of one industry or another. And airline deregulation was certainly the lead among those, which, as you know, came into law in 1978.
Fred Kahn was a larger-than-life, or is a larger-than-life...
small. I mean, a small man, but larger than life.
Larger than life. Tell us about working with Fred on this process. I know he was very, very active, very, very lively in the whole process, and I know you enjoyed that time with him.
Well, I'd had the good fortune to get to know him quite well before I'd gotten to the division. We'd worked on some things together, and I loved the man. I mean, we played tennis together. He shared an interest in Gilbert and Sullivan with me. He loved to go around singing the Lord High Executioner's nightmare song, sort of at the drop of a hat. But a more lively mind and a more insistent advocate of the free market process, it would be hard to imagine. And he, at the CAB, saw it as his role to bring competition into the airline business within the statute, and then as a second step to try to get the statute changed. And as you know, he ended up espousing legislation which abolished the CAB and abolished his own job, and he went on to become inflation czar. As he used to say, it was the very embodiment of the Peter Principle.
Looking back on the deregulation movement, was it a success?
Oh, yeah. Oh, yeah. I mean, it's sometimes when I sit in an absolutely flat-out jammed airplane, I kind of wonder about it. But more people have flown more miles for less money than ever would have happened, ever would have happened, and it's not even close. And as the sort of movement went on into surface transportation and into telecommunications, same thing. The consumer has been the huge beneficiary of it. Not that there haven't been some bumps in the road as we've seen in electricity, but by and large, it was a huge success, and I'm proud of the division's role in it. It was an important role, and I was honored to have some role in it myself.
The other issue that the National Commission dealt with, as you said, was kind of the big litigation, the complex litigation side. You were at the division at a time when both the IBM case was percolating along and the
grinding along, as people usually say.
And the AT&T case was
just
sort of coming together.
Yeah.
How did the division deal with the two of them? They're obviously very, very different cases, and they were at very different points in the process. Tell us a little bit about how you sort of moved the cases along and how you really got the AT&T case to where it ultimately was tried a few years later.
Yeah, it's an interesting question because we learned a lot in the IBM case, and we applied those lessons in AT&T to a major extent. IBM had been going on and on. It was up in New York, in the Southern District of New York. It was being presided over by a judge named David Edelstein, who was not efficiency-minded, I guess is the way I'd put it. He was certainly serious and tried hard, but it wasn't working very well. And defense counsel were playing the process beautifully, and it was just dragging out. And the staff was beleaguered, and it was a tough situation. We learned from that that you should, and by background, I was a litigator, so this was a lesson that made sense to me instantly. You should focus, focus, focus. You shouldn't try to fight along a 100-mile wide battlefront. You should find your points of attack and go straight at them. And in AT&T, once we sort of got ourselves ready for battle, I put in charge a seasoned litigator, Jerry Connell, in charge of getting the case ready, and he conceived, along with defense counsel, of a process under the general aegis of Judge Green, Harold Green, of a statement of contentions process, which narrowed the issues. Finally, the defense filed a motion to, in a sense, get rid of the whole case, and Judge Green, in a sort of a heart-stopping moment, said, "No, this case is not going to go away. Get ready for trial." And at that point, the chemistry of the situation changed entirely. But it was learning the lessons of IBM. It was getting seasoned litigators in charge of the staff. It was having basically a good case. And at the end of the day, having Charles Brown, the president, chief executive officer of AT&T, recognize that this was not going quite the way he had hoped and anticipated. And it was, by the way, it's an interesting lesson because AT&T was very powerful, both inside and outside the government. This was a very good example of the Judge Bell's neutral zone. We were impervious to political intimations from outside the division, and just handled the case on the merits, exactly the way we should have done it.
Excellent. One other area, John, where you were sort of at the forefront of things that have later become much larger and much more significant is the whole area of international antitrust enforcement.
Yeah.
When you came into office, there were blocking statutes. There were all sorts of efforts to sort of not enforce antitrust laws in other parts of the world. Tell us a little bit about what you faced and how you dealt with some of that in dealing with some of your colleagues around the world.
Well, it was an awkward time. The United States, with very few other close allies, was alone in the arena of antitrust, and many of our best friends as a foreign policy matter didn't share our zeal and enthusiasm for the antitrust laws. The British, the Canadians being prime examples. And so the price always of enforcement activity that would involve a British company or a Canadian company or an Australian company was you just knew there were going to be, you had to get your head down because the diplomatic notes were coming right at you. You just knew that. Gradually, sort of by a process of contacts and discussion and negotiation, began to build a kind of a web of cooperation agreements. We won't do discovery in your country unless you're notified first and have the opportunity to comment. The very, very gentle, what I'll call soft cooperation agreements. And we concluded one with Canada, and there was a whole long line of them. And gradually, as everybody knows, the antitrust message was heard all around the world, and now, I don't know, 100 countries have important antitrust laws to enforce, and the world has changed entirely. But in those early days, it was a little tense.
Well, countries like Japan were not involved very much in antitrust. I know you made some initiatives in dealing with the Japanese.
Yeah, it's interesting. The places where the Americans had occupied, in some sense, had either, at least they were willing to listen. The Germans had an actual antitrust law on the books and were at that time sort of the intellectual repositories of antitrust learning in Europe. The Japanese less so. But we, particularly when the Hart-Scott law came into effect and the merger world changed, we decided it was important to get over to Japan and talk to their Chamber of Commerce and talk to in effect, their Wall Street Journal and try to get the message out. And we were very well received. with one exception. We were always told that the Japanese would be very diplomatic and they would never say anything that suggested any kind of disagreement. And we got into our first meeting with MITI, Ministry of International Trade and Industry, whatever it stands for. And I remember delivering this kind of set-piece statement about how it's important for the antitrust laws, and we got ripped up, down, and sideways by these folks. And I remember going out of the meeting saying, what happened to all of this Japanese deference? No deference whatever. They were savage. But it was a good visit, and it's got something started.
International organizations like the OECD were also starting at that time or in their earlier stages?
They'd been going on for a while, and the United States was always the chair of one of the leading committees of the OECD in the antitrust area. So we had a major role, and the meetings were quite agreeable. They were in Paris, OECD headquarters. And it was sometimes there were lengthy reports by the Swiss on their one case a year. But, gradually the sort of momentum picked up and the British began to get interested in this subject. And Sir Gordon Borey, Lord Borey, as he now is, was quite enthusiastic. And so one after another, the momentum picked up and the OECD became a much more active entity than it had been.
As I had mentioned, the blocking statutes, we had the uranium cases.
Yes.
And issues there. How did that come to be resolved, or if it did?
It did. Uranium was a difficult case because it was a situation in which our staff very enthusiastically and very ably were investigating an undoubted conspiracy. There's no doubt that there was a conspiracy. The question was whether it was fair to indict foreign entities for responding to a U.S. government initiative which put them at a huge disadvantage in selling uranium into our markets. And at the end of the day, I made a prosecutorial discretion kind of a judgment that it simply would not do. It was sort of a bait and switch. The U.S. government, on the one hand, sets up a situation where a logical response is for companies to get together to try to figure out what to do about it. And then in the next instant, hammers them with felony indictments. Didn't make any real sense to me. And I remember talking to the staff and saying, this is a case, we're going to focus on some minor players here, but it's not going to be the big case you had hoped for. Sorry about that, but that's my job, and that's why I'm here. And I have to say, in the most professional reaction you could possibly imagine, they said, we disagree with you. We understand your point of view. We don't think there's been any lack of integrity or any corruption here. We understand exactly what decision you've made, and we'll now go on to our next business.
Well, you must be gratified now that investigations go on with 10 jurisdictions cooperating and getting together to, start an investigation on the same day, share information, do all sorts of things. It's obviously a completely different world.
What a great world to live in. It wasn't that way at all.
Now, about 1979 at some point, I believe you were sort of asked or questioned about the possibility of becoming Associate Attorney General. How did that come into being, and kind of what were the steps that ultimately got you to that position?
Well, it was interesting. I wasn't asked. I was in, a whole group of us were having lunch in the Attorney General's dining room one day, and Judge Bell, in the sort of off-the-cuff way he had, said in that impenetrable Americus Georgia accent that he had, something like, well, Mike Egan's going to leave. He was the Associate Attorney General at the time, and John Shenefield's going to take his place. First I'd heard of it. And so afterwards, after lunch, I walked into the Attorney General's office and I said, Judge Bell, what was all that about? And he said, well, I had thought you know how to manage, and the Associate Attorney General is supposed to manage the department, and I want you to be the Associate Attorney General. I'm going to leave, and Mike Egan's going to go back with me to Atlanta. And I want you to be Associate Attorney General. I said, well, let me ask you one question, very pointed question. Are you kicking me upstairs? Have I caused too much difficulty? And he said, absolutely not, has nothing whatever to do with it. I want you to take that position. And thus reassured, I said I'd be happy and honored to.
Excellent. How did And you started in that position immediately or soon thereafter?
Yeah, I moved upstairs. It was it was odd. I think it was August '79. I went upstairs and asked Don Flexner, I think, to be the acting head of the division. We immediately set out looking for a successor, and the then Attorney General, Ben Civiletti, said, I want you to make me a couple recommendations and tell me which one you prefer. And so we went off on that process. In the meantime, I was sort of doing some things to run the division with Don's help, but I was also acting as Associate Attorney General. So I was kind of doing a couple things at once there for a while. I was finally confirmed after a rather lengthy confirmation process owing to the benign attention of Howard Metzenbaum. Finally, I think I was confirmed in January of '80.
Okay. And your successor at the division was who?
Sandy Litvak,
okay.
whom we located. I mean, we had an immense number of good candidates in-house and an immense number of good candidates outside. People loved to be head of the Antitrust Division. It's a great job. And Sandy was a litigator, so he was somebody after my own heart, and he was a good leader, and I think the record shows he was a terrific head of the division.
How did you enjoy being Associate Attorney General?
Well, it was different. I had no troops. I just had a staff. I had a small staff, but it had responsibilities for, as I say, for management of the department, and it had responsibilities for all the civil litigation of the United States. And so reporting to it were the Antitrust Division, the Civil Division, the Civil Rights Division, the Law and the Natural Resources Division, Environment and Natural Resources Division, the Justice Management Division, the Immigration and Naturalization Service reported to it, and then it had a whole range of intelligence responsibilities. It was a very exciting job. And remember that our embassy in Tehran was taken over in November of '79, November 4. I remember it as clear as a bell. And that triggered a whole bunch of other responsibilities, not least of all in the intelligence category, many, many, many mornings in the Situation Room. Very exciting, very heady stuff for a young man.
What kinds of things were you doing on the hostage crisis? What were you involved in as a representative? I guess you were the representative of the Department of Justice at all these hearings.
I was. This was what's known as the Deputies Committee, and it had the deputies of all of the departments, and I happened to be the Justice Department designate. I mean, there were lots of things going on. One of the things that happened was we froze all the Iranian assets all over the world, and then there was a whole wave of litigation about what that meant, and the Justice Department had to preside over the policy aspects of that decision and how to implement it and how to appear in the various courts around the world and deal with it. That was sort of one thing. There was the whole immigration issue. Where were the Iranian students? There are thousands of them. Were any of them security risks? And that whole set of issues. Maybe most fascinating were the intelligence issues, and there we were involved. Justice was involved in all of the covert action findings that the president had to sign under the intelligence law. Had to have responsibility for all of the Foreign Intelligence Surveillance Act applications that came through the department, and so I had a hand in all of that.
Heady times, interesting things.
Yeah, it was fascinating. I mean, I was just looking at something the other day. One of the great heroes of that whole time was the Canadian ambassador, Ken Taylor, a wonderful man, and his immigration person there in the Canadian embassy in Tehran, John Sheardown. When the students came over the wall of our embassy on November 4, there were 5 or 6 of our people who were working sort of outside and around. They found their way, through ways that you can imagine, to the Canadian embassy. And the Canadian embassy decided to shelter them and hide them, and then worked with CIA to develop a plan to get them out of the country. And CIA sent over its chief disguise guy, Tony Mendez, and a whole plot was put together with the Canadians' very active involvement to get these people out. disguised as some kind of Hollywood film crew and changed their appearances and instructed them in what they should be doing. And they were walked out through the Tehran airport right under the nose of the Iranian people and security folks, got on an airplane and flew off, as I recall it, to Germany. And the next day, of course, the Canadians themselves left, shut the embassy, left because they could no longer remain. But Ken Taylor and John Sheardown, still, we owe them, the American people owe them a great debt of thanks. But that was an example of the sort of excitement and headiness of those times.
Now, all good things come to an end, and there was an election in 1980, and
there was.
That was the end of that era, I assume. At what point did you leave the department to return to private practice?
I decided to leave regardless of who won the election. So along about September, October, I began to think about how I was going to do this and actually started talking to law firms. I actually left the department on the 10th of January and went to the Virgin Islands and read Anna Karenina on the day in which President Reagan was sworn into office.
Okay. And then you went to which law firm?
I went initially to Milbank Tweed in their Washington office. Wonderful place, great opportunity to work with Elliot Richardson as an example. Loved it. But 5 years later, I went to Morgan Lewis and have had an absolutely marvelous time there, marvelous career there. Happened to be lucky enough to be chairman of the firm for several years, and it's my home.
During the course of your time at Morgan Lewis and I guess at Milbank as well, you have had a few avocations, I would call them. One is the area of law and national security,
yes.
which obviously you picked up during your time as associate, and you were very, very involved as head of the ABA's Law and National Security
Correct.
group. Tell us a little bit about that. That's, again, in the context of what's been going on in terms of the national security area. Very, very interesting work and very, very interesting.
Yeah, the whole idea of law and national security as a subject matter wasn't in those early years wasn't really thought of, and so the Law and National Security Committee, which interestingly had been established by, among others, Lewis Powell when he'd been president of the ABA, was put in place to begin building this body of law and to teach Americans the relationship between national security as an important national objective and law and doing things under the law. So we did lots of different things. One of the things I most enjoyed doing was on behalf of the U.S. government, but as head of this committee, going to Romania and talking to everybody in their government and everybody in the opposition and journalists about how to set up an intelligence agency under law, responsible to the civil authorities, with a budget that is disclosed to the political branch. Did the same thing in Russia to less effect, but that sort of thing, the ABA, as you well know, has had a big hand in sort of the democracy movement around the world. This was a small part of that.
And one of your trips to Russia, as I recall, had some interesting things going on at the time of one of the, I guess, the Yeltsin.
It was a coup. It was an attempted coup against Yeltsin, which was taking place on the days in which we were there, and in effect, we were meeting with national security people from the Russian government, and a curfew was declared, and we were taken by KGB people down the Arbat and to our hotel, the Radisson, and the tanks began firing at the White House, their legislature, which was 2 bridges up from our hotel. My wife here in Washington watching CNN, I in my hotel room watching CNN, the window open and the percussive sound of the tank gun blast coming in my window. It was a little scary.
Your partners in Washington were also watching CNN that day, as I recall very vividly.
I remember having lunch with Bill Colby, former DCI, and he kept saying, this is just like Vietnam. We had breakfast, and we sat there, and there were tank blasts, just one right after another. And they were On television, you could see the muzzle blast. You could see it hit the face of the facade of the White House, and then you could hear this enormous sound coming, somewhat delayed, of course. We got out the next day.
Well, turning from that to your other avocation, which I think is quite different when you look at it in terms of kind of military issues, the National Cathedral, and obviously that has been a great love of yours, and you've done great work. Tell us a little bit about what you've done at the Cathedral and what kinds of projects you've been involved in there.
Well, I started at the Cathedral in 1947 as an 8-year-old boy soprano and sang, went to the school, St. Albans School up there. And so it's a place in which has been right at my roots. I've come back to the Cathedral over and over again, and I've been fortunate enough to have a role in its governance, and I've been chairman of the Cathedral chapter for the last 7 years that I've loved. The Cathedral has a great role in the nation's life, as you know. Perhaps the most moving service I've ever had a personal role in was after September 11, the September 14 service. And I have to admit, when the entire executive branch and the entire legislative branch in this jammed cathedral began to sing the battle hymn of the Republic, the hair stood up on the back of my neck. But the role of the cathedral, even more than that, is as a place of sort of generous, spirited Christianity, a place where there's the opportunity for safe convening, where there's the opportunity for interfaith dialogue and reconciliation. So lots going on up there. It's an exciting place to be. It's got a wonderful staff, and I've treasured my time there, and that's where we worship.
And more recently, you have been a member of the Antitrust Modernization Commission, which was your second national commission to deal with the antitrust laws.
You know you've been around too long when you have the second commission to look at the antitrust laws.
Well, tell us about that commission and what they did and your role there.
Well, I was a member as opposed to being chairman. That's one difference. It was 3 years as opposed to the 6 months. The Shenefield Commission was 6 months. It had the entire set of antitrust laws as something to look at as opposed to the two focused inquiries. It was very exciting, though. Deb Garza was a very, very able chair. We had a very good staff. Andrew Heimert ran it from the Federal Trade Commission. We had exciting testimony. We had all sorts of very good contributions. Your antitrust section of the ABA was chief among those. Absolutely first-class work. And so we were able to make a series of recommendations. I hope some of them get into being. Unfortunately, Washington is a city of a repository of commission recommendations that nothing ever is done about. Something should be done about this. It didn't get to everything, and there were things that I was sad we couldn't do. But it was a thoroughly gratifying experience, and it sort of remains for the next administration and the next Department of Justice to push some of those initiatives forward.
It was an exciting time. The section got to provide a set of comments to the AMC and others during my year as chair every 2 weeks. So literally, we put out 26 sets of comments.
Well, your stuff was excellent. I know there were a lot of people who were working on it, but it was first class intellectually and very sensible as a policy matter. And as you well know in this town, you can get stuff that's lousy or extreme or both. Your stuff was neither.
Well, it's not my stuff, it's the section stuff, but I remember one of the sets of comments, there was a very specific question put to the section or to public comment by the AMC, and we provided a one-page answer, one-page response, which I thought was impossible in Washington. And it's good to see that we can kind of focus issues in that way. But it was a very, very interesting time to deal with the antitrust laws, and hopefully, as you say, something good will come out of it.
The one thing that wasn't done that needs to be done is the next stage of the deregulation examination. And one thing I would urge the next head of the Antitrust Division to do is to get with his president and try to set up a commission to look at the next stage of deregulation, because the the economy is still riddled with these regulations that raise prices and inhibit entry. And there are all sorts of ways it could be loosened up to the huge benefit of the average American consumer.
John, looking back at all the things we've discussed in your great career in the antitrust world, what would you say is your greatest accomplishment or your greatest accomplishments in the antitrust world?
Goodness. Gosh, so many, your life passes in front of your eyes. I think one of the things I'm proudest of is my time at the division. Not a specific thing because there were so many of them, but my time at the division. I came to love the antitrust division and hugely admire the people who were there. Still have many, many friends from those times and indeed more recent times. And what I want to call to everybody's attention was the great change. Remember that in the early 70s, there had been the Watergate problem, and the antitrust division did not escape that. There was the famous Dita Bird episodes and IT&T and all the rest. And the result was that everybody in federal government and in the Justice Department in particular labored under this incubus, this weight of Watergate residue. We cleansed the place. We got to the other side of that crisis. We laid all those ghosts and put all of those things to bed. And so, if you say what am I proudest of, I'm proudest that I left the division in a situation where no one would ever think to question its lack of integrity. It might question its lack of judgment or its lack of competence, erroneously in my view, but they would not question the integrity issue at all.
Looking back also, has the enforcement of the antitrust laws improved in some ways, in other ways? Do you have any comments generally on how the antitrust laws can be more effective or should be more effective in today's world?
This sounds like a dangerous question to me.
It is a very dangerous question.
I'd say yes, they've improved in a lot of ways. I think the criminal process is better now, not least of all because the leniency policy is just much more effective. I'm glad we got it started, but it's better now than it was then. I worry sometimes about the criminal process. The Antitrust Division is not the U.S. Attorney's Office and shouldn't seek necessarily to emulate the U.S. Attorneys. I always thought it was helpful to have what I'll call senior, mature legal judgment on those questions of prosecution or not and remedy and all the rest. Regrettably, somewhere along the line, and I think it may have been under Bill Baxter, the head of the division, in effect, delegated all responsibility for the criminal prosecutions to a deputy. I think that's a bad mistake. That's easily the most important thing the division does. And to have the head of the division, in effect, say, I'm not going to have anything to do with it, is just wrong. So I would restore that to the control of the head of the division. I would also try to make things a little less mechanical. I think there's an important role for discretion in thinking about prison terms and all the rest of it. The sentencing guidelines are a problem, I'm aware. So that's that. I think maybe surely economics has been a huge influence for the good in antitrust enforcement. I think it's perhaps gone a little too far. There's a sort of a presumption that markets are self-correcting, and therefore it's okay if the division just sits back and watches things self-correct. I think that's bad policy. I think there are times when you've got to get in, you've got to do your enforcement work, you've got to get rid of the problem. Sure, you may not get it exactly right, but you shouldn't let the perfect be the enemy of the good. Get in, bring the case, enforce the remedy, get out. Microsoft was a terrific case, well tried. The settlement was less than robust, but it was a good example of what could be done and what should have been done.
And on that note, John, I think we will finish. This has been a wonderful hour. We very much appreciate your taking the time to reminisce and talk about so many of the issues that have affected the antitrust world over these years. and it's been a great pleasure to have you here with us
today. It's been a pleasure, Don. Thanks for the
Thank you.
opportunity.